the petitioner claims that there is an incumbent bias as a large amount of money go to the ruling party. It is submitted that whether such an incumbent bias exists, and if it does, what its extent would be is a question wholly irrelevant to determining the constitutionality of the scheme. And my lord, I have already said that that has been the trend. The ruling party gets maximum because ruling party has the confidence of the maximum people. Now, my lord, page 65 bottom. My lord, I have said that secrecy per se is not alien concept in even electoral issues. Secrecy of ballot.
That's something separate. In the uneven level playing field, you have referred to fairness of elections. That issue is not been addressed.
Correct.
Has that issue with regard to fairness in elections been, or because of the mismatch between the money power, has that been addressed here? Because that may be a larger picture, not specific, like alone to.
I'll just, my lord, again, my lord, try and attempt to point out.
No, you have argued that because of ruling party has always been getting substantially more donations.
Lord, average Indian voter, be it corporate or an illiterate voter, my lord, we have to accept this fact, and we should be proud of that fact. He is a very intelligent decision maker. A ruling party in 2013, though ruling party may not get maximum political contribution, because the voter knows that in 2014, the wind is somewhere else. We have to trust his discretion. So ruling party is not getting maximum because of the scheme. That's my submission.
According to even otherwise, the ruling party would get.
Always. Lord, even before this scheme, I have shown from 2005 to 2014, whoever was ruling party, Lord, BJD is a ruling party in one state of Odisha. They have maximum political contribution. That's the trend. That's how the people of India contribute. It's not as if because of the scheme the ruling party is getting any benefit and there is no level playing field. My lord, I have analyzed, my lord, in secret ballot that secrecy per se is not antithetical to free and fair elections. Sometimes it enhances free and fair elections. Like, my lord, in my respectful submission, the present case. How, my lord, this scheme accelerates or enhances free and fair election, my lord. It is submitted that your lordships have, my lord, para 165, my lord Justice Padiwala.
Yes.
It is submitted that a conjoint reading of the principles of secret ballot and the right to privacy under Article 21 clearly postulates that there exists a claim on part of the donors to make donations without fear of reprisal. It is submitted that such right would obviously not be absolute and would have to be counterbalanced with public interest and concept of free and fair elections, and further optimized with policy interest of bringing the first step of shift from cash to banking channel in political donations. It is submitted that the balancing element in the present policy is clause 7(4) of the Electoral Bond scheme clearly provides for disclosure in case of appropriate proceedings before the competent court or criminal proceedings. Lord, financial policy and limits of judicial review. Lord, I am not going to read the whole. I'll just read the highlighted part because that would, my lord, in the facts of the case, be very, very relevant and direct for assisting your lordships. Lord, first is Rustam Kawasji Cooper. Your lordships, Lord, know the judgment. Lord, it's a bank nationalization case. 2203.
It's a PDF.
My apologies, I stand corrected. I am obliged to my Lord Justice Padiwala. It was then urged on behalf of the petitioners that my Lord Justice Gawai got that Section 4, Clause C operates only in relation to a period before the date of maturity of special bearer bonds, and after the date of maturity, the holder of special bearer bonds can sell such bonds and without running any risk disclose the consideration received by him as his white money, because Section 4, Clause C, being out of the way, he can account for the possession of such money by showing that he has received it as a consideration for sale of special bearer bonds. And so far as the purchaser is concerned, if he has paid the consideration out of his black money, he can claim the immunity granted under clause 3. Thus, the black money of the seller, which had been converted into white on his subscribing to or otherwise acquiring special bearer bonds, would remain white, and in addition, the black money of the purchaser would also be converted into white by reason of his purchase of special bearer bonds. This argument, plausible though it may seem, is in our opinion fallacious and cannot be sustained. It is highly debatable issue whether, under the provisions of the Act, special bearer bonds are at all intended to be transferable after the date of maturity. Here, my lord, 15 days. Here, their maturity was long period. For the postulate of the legislation clearly seems to be that on the date of maturity, the special bearer bond will be encashed. It is indeed difficult to believe that anyone holding special bearer bonds would keep them uncashed without earning any interest from and after the date of maturity, when they can be immediately encashed and the amount received can be invested yielding interest ranging between 18% to 40%. Moreover, special bearer bonds would cease to be exempt from wealth tax from and after the date of maturity, and they would therefore be includable in the net wealth. My lord, last line of this paragraph, my lord. But the law cannot be condemned as invalid on the ground that after a period of 10 years, it may lend itself to some possible abuse. Lord, please come to para 19. Lord, the argument that black money would be promoted is dealt with, my lord. Lord, please read, my lord, para 19, my lord. It's a long para. I don't propose, my lord, your lordship's time. But it's a similar argument that you are encouraging black economy. The court, my lord, analyzed the entire scheme and said that no, it brings the clean money into the system. Now, my lord, coming back to my written submissions, my lord. My lord, please come to para 78. My lords are aware, but I am always tempted, my lord, to show these judgments, my lord. The Lochner era, my lord, which is known as Lochner era, where the Honorable American Supreme Court was having 7 honorable judges, and whenever there was a economic policy change by the president, it used to be struck down with the majority of 4 versus 1. And popularly, the 4 were known as 4 horsemen, and less known fact is 3 were known as 3 musketeers. That in America this is possible, but be that as it may. No, I'm sorry, 9, but one was being convinced by Justice McReynolds. It is believed that he used to convince. But let's not go into it. Lord, this is Lochner versus New York, ultimately overruled. But my lord, your lordships would recall, Lochner versus overruled starts with a dissent by Justice Brandeis.
Justice Holmes as well.
First by Holmes, thereafter Justice Brandeis, and thereafter that popular article written by Justice Brandeis on privacy in Harvard Law Review, and eventually, my lord, this was the Lochner was, my lord, declared, my lord, not to be a good law, my lord. That also I have, my lord.
All right, we can skip.
But, my lord, it says the government or the legislature, not the government, the legislature has a right of trial and error. No, this is accepted by our court recently, my lord, reasonably recently, when IBC was challenged. But there were several issues in IBC. There were several lacunas pointed out in IBC. But the court said that free play in the joints will have to be given. Even trial and error, unless it is so abhorrently or atrociously arbitrary that it can never satisfy our conscience, the court would defer to the wisdom of the legislative action.
Even in demonetization, we have also.
I have, my lord, relied upon that, my lords. Please see, my lord, at, where is the judgment? I've just, my lord, we have quoted that judgment, my lord, your lordship's judgment in demonetization. But I'll just, my lord, give that site. Well, but the pagination, Lord, I have not marked, but I'm relying upon that.
Vivek Narayan Sharma.
Pardon, lord?
Vivek Narayan Sharma.
Vivek Narayan Sharma, lord. Or page 76, my lord, I'm sorry. Page 76, my lord. My lord, it is page 76, my lord. Vivek Narayan Sharma versus Union of India. The lordships would find it at it's 2023 SCC online, page 1, where my lord also accepted, my lord, this proposition that government can have trial and error unless it is ill-intended, so atrociously arbitrary that it shakes your lordship's conscience, or it doesn't achieve the object it seeks to be achieved, or it is for a different object. Lord, suppose the object would have been that the government of the day, the ruling party, would like to know who paid what to whom. Lord, I have therefore, my lord, satisfied your lordships that please criminalize if there is any breach of confidentiality. Your lords, my lord, one of the questions, my lord, only 5 minutes, my lord, was what happened after the scheme was introduced. What is the trend, my lord? My lord, that we have given, my lord, in document number 2A, which, my lord, we highlighted yesterday. My lord, these are figures, and my learned colleague, my lord, has examined these figures. If your lordships can give him 5 minutes to explain what is post-scheme situation, my lords.
Okay.
My lord, that he would be able to do it better, my lord. I am never good at figures, and my lord.
Doing 2A, no?
Please, my lords, it is the compilation that is on the screen right now.
Yes.
If my lords would come to PDF page 8 of that compilation, it would show the party-wise income from unknown sources. This is a report by the ADR itself for financial year 17-18. So this is the pre-electoral bond scenario. In the first table, so Annexure 1, party-wise income from unknown sources, financial year 17-18. The first table has on the left-hand side column the name of the political parties. The second column, now this is the pre-electoral bond scenario because 17-18. Second column has the voluntary contributions below 20,000. I believe the Solicitor General has already explained that how this below 20,000 rupees mechanism was previously a sort of a loophole where contributions could come in without there being any identification. So this shows that how the first party has received about 342 crores in this financial year.
Yeah.
The third political party has received about 36 crores in this financial year. And the numbers go on. In the second annexure, my lords, if my lords sees the third political party, the total income from unknown sources is 39 crores. That contributes to about 37%